class, and welcome to Unit 2. In this class, we will be talking about Fourth Amendment issues of search and seizure. The Fourth Amendment protects against unlawful searches and seizures. For a search and arrest to be reasonable and lawful under the Fourth Amendment, a police officer must have probable cause for the arrest. To establish if there was sufficient probable cause for the arrest, the court uses the totality of circumstances test, a test that analyzes all the circumstances of a particular case rather than any one particular factor. In other words, what were all the factors considered when determining if there was probable cause to make this arrest? And are these factors consistent and credible? In addition to probable cause, the police may also need an arrest warrant. And I say may also need because this is not always the case. The arrest warrant is only needed for arrests taking place at a person's home or place where they feel safe and comfortable. In public places, there is no need for an arrest warrant. The reason that the arrest warrant is only required in a person's home and not when the person is in a public place stems from the idea that there is such a thing called a legitimate expectation of privacy in one's home and not when one is out in the public. To simplify where there is this legitimate expectation of privacy, ask yourself, if you were the defendant and the place where you were arrested was a place where you felt safe going to sleep without any intruders harming you or your possessions in the middle of the night, this is a place where you would have a legitimate expectation of privacy. It also happens one's home, but also sleeping over at a friend or relative's home or in a hotel room that you are a legitimate paid guest at. However, if you were the defendant and the place where you were arrested is not a place where you would feel safe going to sleep without intruders harming you or your possessions, this is a place where you would not have a legitimate expectation of privacy. Examples of this would be public parks, sidewalks, train stations, stores, or an office space where you are not authorized to be in. We will be reading two cases on legitimate expectation of privacy in this unit. One is Minnesota versus Carter, and the other is Minnesota versus Olson. And in these cases, the court decided what elements constitute legitimate expectation of privacy, necessitating the police to obtain an arrest warrant in order to make the arrest. If the defendant wants to challenge police action, the defendant must convince the court that the police violated his or her legitimate expectation of privacy. Otherwise, the defendant would have no standing to challenge the police action. Also in this unit, we will discuss the doctrine of illegal arrest is no defense. If an individual claims that the arrest was illegal, can he or she get the whole case thrown out of court? The answer is no. Under the doctrine of illegal arrest is no defense. The court is not concerned how the defendant was brought into the court. As long as the defendant is in court, the court can exercise jurisdiction over that defendant. However, once the defendant convinces the court that the arrest was illegal, the evidence that was obtained in the course of this illegal arrest must be excluded. This is the protection.